Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about judicial ethics. Cases that should have gone to the Supreme Court of Canada, but didn't. Judge Jean-Paul Braun relied on one of the myths about sexual assault stereotypes, that because the complainant dressed a certain way or looked a certain way, that they were more likely to consent to sexual activity. As a result of that, his judgment, in the case in which he relied on that myth, was overturned. The Canadian Judicial Council also instigated an investigation to determine whether there had been a breach of judicial ethics as a result of reliance on that stereotype. And the judge argued that the investigation, and the investigation in particular into the manner in which he rendered his judgment, went outside the scope of the authority of the Canadian Judicial Council, in the sense that how he rendered his judgment, or reliance on an improper, legally incorrect myth about sexual assault stereotypes, was something that would not be the subject matter of investigation for the Canadian Judicial Council. He also asked the question of what the standard is for reasons for judgment constituting a breach of judicial ethics. And this case raises very important issues. Not only do we see now mandatory sexual assault training for judges in the Canadian judicial system, but we also see a need for that, argued by Parliament, as a result of the fact that these types of judgments were happening. It's difficult to say that there's been a breach of judicial ethics simply because a judge is wrong in the law, even where that wrongness in the law is based on stereotypes that are impermissible in the cases. Because individuals from various practice areas can be appointed to the bench and then have to decide cases that have nothing to do with anything they had any experience in while they were working as lawyers, it raises the concern for the use of improper reasoning, and that's why we have an appellate process. How does the ethics investigation into the conduct of a judge really square with the role that a judge is supposed to play in reasoning and dealing with it, and the role that an appellate court is supposed to play? And when does it become a breach of judicial ethics to just be wrong on the law or be wrong on the facts? And isn't prosecuting this judge under an ethics complaint potentially opening the door to allow more judges to be the subject of more ethics complaints, which means more investigation by the Canadian Judicial Council, which then slows the speed of the justice system as a whole while judges are under investigation and having to deal with the impacts of that simply because they got the law wrong, or because they stated a fact wrong, or because they relied on impermissible reasoning? We've seen convictions in Canadian law for offenses that no longer occur because judges just didn't know. And does that really amount to a breach of judicial ethics? Where is the line? The Supreme Court of Canada had the opportunity to chime in here and answer this question, particularly at a time where we're going to see more training for judges in relation to the sexual assault laws in Canada, and hopefully avoid these types of situations. But of course, that's not going to stem the tide of all sorts of other wrongful reasoning and wrongful convictions, and potentially acquittals that are not based on a proper analysis of all of the evidence. And to expose judges to the risk of a Canadian Judicial Council complaint for simply being wrong might be dangerous, and the Supreme Court of Canada should have had the opportunity to say something about this. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.